Well, I'm always grateful to have the opportunity to talk about proposed amendments to our legislation. We have the intellect, the insight, the enthusiasm and eloquence of some of our senior civil servants. That makes the discussion not that much more informative, but interesting and engaging. Welcome to the studio, Mr. Wilbur. Welcome. Deputy Chief Officer in the Ministry for Lands. Good afternoon, sir.
Good afternoon.
Always a pleasure to see you.
Yes, same here.
Miss you from, General Registry when we could talk about, NPOs and the like. So, yes, I guess upward and onward.
Yeah, it's been too long though, too long.
Too long? Well, I had a desire to extend an invitation to you, but I was told I need to get my people to call your people, and I don't have people, so.
Well, I don't have people either.
Well, equal to join us, the Registrar of Lands, Miss Sophie Williams. It's a pleasure to publicly welcome you to our studio, and hopefully we'll have the opportunity in the years to come to, include you in our public discussion, because I think lands and access and understanding that we have probably one of the best land registry systems in the world. I think it's something to laud, but it's also important to understand how significant, complex, and technical it can be, but easily accessible by the public, even just through your counter. So, good afternoon to you, ma'am.
Good afternoon, and thank you for having me.
All right, it's a pleasure. Mr. Welcome, from that perspective, as we look at, when our Legislative Assembly, sort of convenes and it passes laws and makes amendments, when government proposes bills for public consultation, sometimes as a populace, we don't always appreciate that this thing will affect us at some point in some meaningful way. Maybe those of us who are, conveyancing and perhaps looking at the importance of it because that is our profession, may see it, whether it's the banker, the lawyer, whether it's the real estate agent, or even the surveyor. But even the general, public sometimes need to be mindful. Yes. So our discussion today would be very grateful for you to guide us in a direction as we look at the proposed amendments.
Okay, so the general public listening, I think, would be cognizant of some issues we've had regarding access to the beach and public rights of ways, or beach accesses as we colloquially call them. These two amendment bills, when combined, the provisions therein seek to do something that's not done in other jurisdictions, which is register these rights of ways as encumbrances on the land registers of these particular parcels. And again, I want to reiterate that nowhere else in the world do we see where where public rights of ways are registered. So it's something unique that we're trying to do, and I think we recognize the importance of doing it here in Cayman to protect those historical beach accesses that our ancestors have used from time immemorial. Mm-hmm. So the two amendment bills seek to provide a specific legal framework to allow the Registrar of Lands to register rights of ways that we've acquired by what we call prescriptive rights, mm-hmm. Which is uninterrupted use for over 20 years. So the two amendment bills, when combined, they provide a legal framework and a step-by-step process of how to enable the Registrar of Lands to register those beach accesses.
If I could then ask, and perhaps if nothing else, maybe for my own personal edification, but we have, and if I follow along Mr. Wilbur's perspective, had this understanding within the Cayman community that let's say a beach access or this particular path, we've always used it. The grandparents who use it, there's never been any encumbrance, any hindrance in moving from point A to point B along the path. Mm-hmm. So therefore there's this public right of way. And then we understand somewhat, there's prescriptive right and it's there. Is it now that because that has always been there but it's never been formally sort of registered and recognized, that unless you do something to acquire that and register it, then it can be removed? Is that part of the problem, Ms. Williams?
No, not that it can be removed. What the bill is seeking to do, as Wilbur said, is to allow us the opportunity to have them recorded. The difficulty with it not being recorded is that it tends to lend itself to dispute between a landowner and members of the public, where the landowner may be saying there is no prescriptive right of way. The public is saying, yes, we have been using this from time immemorial. Or the landowner may be purchasing property and he's not aware. We have a lot of persons who purchase property who are not Caymanians, or persons who are Caymanians, but they may be purchasing property where they are not aware of the full history of the property. So they could, not saying that it happens, but it could be that they're purchasing property and they're not aware of that public right of way. So what the amendment seeks to do is to have these right of way endorsed on the land registers, which would then operate as notice to the entire world that this property is subject to a particular right in favor of the public.
Okay. Now we know that especially in when property is being purchased, someone has a piece of property at what they call the backland, someone has it near the road, they would acquire an easement over that property. So we understand that whether it's vehicle access or 6 foot, 12 foot, whether it's just a footpath, just to give them access. Is it then that in this, again, in the Cayman context, is it then that in the instance, the path is there, the right of way is there, but unless you claim and acquire it, then it's not there? From the public's layman's perspective.
No. Well, it is there. Not that it is not there. This right of way to the beach, it does exist. It's just that it's not recorded with any particular government department or any other department where somebody can say conclusively, yes, that this exists. So what the current law allows is that it recognizes, the prescription law recognizes you can acquire an access by prescription, but it places a lot of burden on the public, on the members of the public.
So then to acquire it, you have to formally make application. You just can't assume it's there.
It's what we're hoping to do with this amendment. So you have the prescriptive right of way. Once you've been using it, you have acquired it. And the legislation previously is if there's a dispute as to that particular right of way, you can take it to the Grand Court, and it assumes that if there's no dispute, it just stays there time immemorial. And what this happens, and I mean, I don't mean to get too technical with members of the public.
Please do, yeah.
Is that usually because of our system of registration, which follows a torrent system of registration. It just assumes these particular rights that exist, that it assumes these rights exist, but it doesn't allow for it to be registered, which is when we were doing our research and we looked at other jurisdictions which have public beach accesses, such as Australia, which has a similar registration system as ours. They're simply not registered. So what we're hoping to achieve is, once they're registered, we're hoping that it would lead to a significant reduction in disputes between landowners and members of the public, because then at the very least you will see that this public right of way exists and that it is there, and there's not that much doubt around whether or not this exists. It's the landowner's concept of what he thinks that he owns as to the public concept of what they remember in terms of using the particular parcel going to the beach. Okay. So what we're hoping to achieve is that it's going to be registered, and once it is registered, it is noticed to the world. All right.
So we're talking about beach accesses, but would this also apply to, forgive my term, footpaths that we see exist through different properties, and it's always been there, everybody knows it's there, but would it also apply to them, or specifically just to beach access?
It would apply to public rights of way.
Public rights of way.
Public. So that would include footpaths as well.
What about instances of former paths that existed and now have been developed? So I give the probably most striking example, the old Galleon Beach Hotel if my directions are right, on the south side, so between the Galleon and Governor's House, used to be a path there. Everyone was there. Then they built the new building that is the spa. So that's probably 2 decades ago or more. But there was a path there. If there was a path that existed way back when, that has now been built on, is this retroactive and those properties need to be torn down, or is it too late to the game? Just to get a little involved.
It's a difficult question to answer, because there are certain cases that have been settled under public beach access, and they speak to when those rights crystallize and when you acquire those rights. So in those particular circumstances, it may be that the Public Lands Commission may have to ask the court for further directions on that matter.
All right. Could we ask one other one just specifically for that? So beach access is those public rights of way, footpaths, and what about roads? Roads that perhaps two subdivisions, for argument's sake, or roads where people have traveled unhindered, enter one point, wind their way through, and exit another point. they're paved, they're somewhat paved, and people have always used them. Does this legislation apply to vehicle roads that we drive on? Not the A1A, not...
Not in my opinion. The majority of the roads are they're government-owned roads, which are public, and there are quite a number of roads through subdivisions that are private roads, and they're usually governed by an easement that is recorded on the register, and the easement may grant access to each lot owner and their invitees. So it would depend on the circumstances. Like I said, it would cover all public access, whether it is a footpath, whether it's vehicular access and accesses to the beach.
Okay. And as Mr. Wilbur would know, but I say public, the intent is just to engage and to understand and to try to aid in clarification. But if we're thinking of the prescriptive law as maybe the layman might understand, on the premise that, well, we have used this thing for the last 20, 30, 40, 50, forever and ever, and you can move through without anybody putting up any sort of impediment, even for a second, to stop you from getting through this path. If it's a road, vehicle, or bicycle, or foot, are you saying that it may or may not apply in this instance? In particular, if it's a vehicular path through a subdivision? It seemed it would apply, but I just wanted to maybe tease the brain a bit.
It's a bit of a difficult one because one of the things the prescription law speaks about, the way you acquire prescriptive rights, is if it's given by consent in writing, which is an easement would be in writing on the register.
Right.
So you could get away. One could make the argument that you can't acquire prescriptive rights because it has been given. You have given consent for its use in writing.
Okay. But also too. Sorry, go ahead.
And the second thing is because they remain private roads. The only way I understand to make a private road a public road would be through the gazettal process.
Okay. Or if government has come in and maintained it and is assumed that it's taken over, is that was a common practice to be understood? So a subdivision that once the developer has sold the lots or dealt with it, government would come in and maintain or somehow resurface the road. There was this expectation that then it would become a public road.
I think that might be the expectation, but I think the only legal means to do it is through the gazettal process.
Okay. Yeah. All right. Interesting. And I think this speaks to the whole issue of understanding the legislation and the intent, but also what the public may have assumed and in fact isn't in law. So you guys got a good job ahead. All right. Tell us more about these two bills now. Are they out for public consultation?
Yeah, so the prescription amendment bill and the registered land amendment bill were gazetted, I think, on September 16th. September 16th, both of them were published. And that would be before the 21 days required for this upcoming sitting of the LA. So we're hoping to have those heard during the sitting that's starting next week, Wednesday. So just quickly to go through the bills, I'll start with the prescription amendment bill. The major change is to Section 9 of the bill. Section 9 of the bill currently provides a mechanism for disputes. And that's if the government or a person concerned in the public right-of-way has a dispute, whether it's, the size, the where it's located, whether there's some type of obstructions. So Section 9 currently provides for that. And Section 9 currently says where there is a dispute, you need to go to Grand Court to settle that dispute. The amendment that we're making is to add in a new subsection on the 9 where it says if there's no dispute, the Registrar of Lands shall register the public right-of-way in layman's terms. So the law already deals with if there's a dispute. So some of those you mentioned where we would consider the block a type of blockage as some type of dispute, then it's incumbent on a person concerned, or as the amendment in 2018 to the prescription law allowed for a government department or agency to take the case to the Grand Court on behalf of the public.
This would be the Public Lands Commission?
Yeah, so the Public Lands Commission is being added in that particular subsection as well. But it currently speaks to a statutory authority or other body or approved by the government, or words to that effect, can take a case that is in dispute to the Grand Court. So that's already in the law. So what we're adding is if there's no dispute, so it's not blocked, we're still using it, we can take it to the registrar, and the registrar shall add it to the register, is essentially what we're adding. And again, the reason for that is we want these things crystal clear, so if you go down to 7 Mile Beach tomorrow and you want to purchase a piece of property, there's no questions whether that footpath over there started 5 years ago or has that been being used for 200 years. If you have it on the back of your register, much like you would have a charge or other types of instruments on the land register, you can say, well, okay, I see that I have a public right-of-way here on the western boundary and it's 12 feet wide, so I know I can't touch that. But at least I know what I'm getting into. Now I can go back to the person that's selling it to me and say, well, I want a little discount because, I lose that portion. But without that on the register, and you going to inspect the property, you may see a footpath, but again, you have no idea whether it's 5 years, 10 years, been used for 50 years, unless someone from the public comes up to you and says to you, well, my great-grandfather pulled up his catboat down there and he traversed this, so this is a prescriptive right-of-way. So that's the reason we want to get these on the land register. And the intention is to, once these amendments are made, if they are approved, we register the ones that are not in dispute, and then we can separate the ones that are in dispute and take those to the Grand Court.
All right. Well, we have an opportunity, if you wish, to invite our callers into the discussion. If you wish, we're speaking to the Registrar of Lands, Sophia Williams, together with Mr. Wilbur. I always want to say, e-banks, but just kidding. You know my joke, right? Adam and Eve were e-banks is, right? So from SP. Let's go to the phones and invite this caller. Hey, good afternoon and welcome. Thanks for calling.
Hey, good afternoon, Dave.
Hey, my friend. Good afternoon. How are you?
Okay. Good afternoon to you guests.
Good
Good afternoon, sir.
Just concerning the public beach access, how far apart are these public beach access supposed to be?
In what sense? I mean, maybe they follow your question about how far apart. Okay.
Well, say if you have one in a certain area.
Okay.
And you're able to make another one further down, say 100 yards away from that one.
Mm-hmm.
Now, how does the law? How is it the law has it in place?
Okay.
So currently, it's actually under the planning law, and I think specifically it's the planning regs that specify those ones that you're talking about. That specify a certain distance between them. So I think the planning regs currently speak to if you have 200 feet of continuous beachfront property, you need to provide at least 1 6-foot beach access. And those ones are usually done as a condition of your planning approval, and then registered as a dedication on the land register. But the prescriptive ones that we're talking about that have been used in time and memoriam, there's no requirement for any distance between those. It is just where our ancestors would have traversed. So, I mean, you could have one where you're standing, and then 15 feet away you could have another one as well. So again, the prescriptive ones are simply where people have been using, and the law requires if you have 200 feet on the beach that you need to give at least 1 6-foot access. That's a condition of planning approval.
Okay. There's a situation in Bogasan Road in West Bay. You know where that is, right?
Yes, sir.
Okay. There's a public beach access in Bogasan Road where there's a sign. And then there's another area where there was a public beach access between two properties also. Right now, where that other one was that does not have a sign, they now have a gate there. And the gate is locked with a padlock. And it has a sign on it saying that only certain individuals that stay at a certain condominium complex that has just been built are able to have access to that beach access with a key. No one else. And the area where the public beach access sign is, the government sign, in that area, if you try to walk from there to the other area which does not have the sign, which has the gate that is locked now. There are a lot of rocks in between in a certain area, and if there's an emergency, if an ambulance has to come and assist someone on the beach, say in the area where they have the gate locked right now, that only certain people with keys are able to have access to that beach access. That means then that the ambulance will have to go almost 200 yards up along the road where the public beach access is and walk from there to where the area is, where the gate is locked, in order to assist someone that might be needing assistance, an emergency assistance. And as we know, when it comes to a matter of life and death, time is very important.
Mm-hmm.
Yes.
So I don't think it's fair for access that was being used for so many years to all of a sudden be closed, and with a sign on it saying that only those individuals who stay at this condominium have access to this area. Because if someone in that area where the gate is, if someone in that area needs assistance, ambulance assistance right away, that person could lose their life because of that gate being closed. And I don't think that's right. Thank you very much.
I appreciate your input. And if you wish to respond now, we could...
Just to say, I would have to do some research on the one that's blocked. If it is a registered one, we have the ability to take enforcement action. If it's not registered, it would be one of those that we mentioned earlier that we would, the PLC would be collecting evidence and taking forward to the Grand Court, because clearly with the gate in place, I would think the landowners are disputing the existence of a prescriptive right.
And in this particular context, I would just encourage the caller if they could give us some more specific information as to that particular blocked access to the Public Lands Commission. It's very difficult to answer a very specific question on that particular parcel when we don't have that knowledge. But if we could send that information to the Public Lands Commission, they do have inspectors who would be able to go out and do an inspection of the parcel to see whether or not it is public, whether or not it is in fact blocked.
Okay. So when we come back from the break, then tell us, take us through the legislation, the proposed legislation, but also talk about what the public can do with respect to bring in things that they believe, may be of value to the fore. All right, going to pause and take a break. The phone lines are open. If you have a call, a comment, a question, you just have a query. We're talking about the proposed amendments to the registered land law and the prescription law. Stay tuned for Talk Today.
The 25th Rotary Central Music Extravaganza is here. Saturday, November 28th is the date. You, yes you, look in that mirror. You can be the winner. $40,000 is waiting for you. Second prize, $4,000. 6 $1,000 prizes and more. Tickets now on sale for only $25 through Rotary Central members, ticket sellers, eventpro.ky, Funky Tangs, and others. Get your golden tickets now. Get ready to be a winner, because you, yes, you can be that winner. The Music Extravaganza 2020, supporting over 70 Rotary Central projects throughout the Cayman Islands. Rotary Central is a not-for-profit number 232. Rotary opens opportunity.
Water Authority Cayman wishes to advise its valued customers and the motoring public of planned works to upgrade the water supply infrastructure along North Sound Road between the junction of Portland Road and Shedden Road. Work will begin on Sunday, 20th September and will last for approximately 6 weeks. During the course of the works, portions of the road will be closed and traffic will be diverted. Signs will be in place directing the flow of traffic. Motorists are encouraged to drive with caution when they are in the area to protect their safety and the safety of the authority's staff. The Water Authority appreciates the patience and understanding of its customers and the public as it undertakes these works and apologizes for any inconvenience this may cause. Your Radio Cayman 6 p.m. news, Monday through Friday, is brought to you by Logic. Your life connected.
Registration is ongoing for the Department of Tourism Pride webinars. The tourism industry is ever evolving. Stay up to date with the industry standards, best practices, and ensure you are the best ambassador for Cayman. The Pride webinars offer customer service, business acumen, history, and cultural classes. Webinars will run on Tuesdays and Thursdays at 11 a.m. To see the full schedule and register, visit pride.ourcayman.ky.
Talk today. But I do have some questions. Talk today.
Cayman Islands' foremost listeners' participation program.
Talk today.
Because there are more questions than answers.
What the public is saying.
Waging to take your calls right now. Sterling Dwayne Ebanks.
Hey, good afternoon and welcome, and thanks, for listening, for sharing, and if I may say, thanks to our stellar civil servants, our Registrar of Lands, our Deputy Chief Officer, for being exemplary in your actions and this endeavor to educate and inform the public. It makes you feel good to be a public servant. And legislation like this, I think, is one that we don't really appreciate how significant it is until there is an issue. Like most things, What I say, he who feels it knows it. So beach accesses may have been the impetus for bringing this to the fore, but then I think it can dovetail into almost any type of access that may have, in your mind, existed. So the registered land law and the prescription law, these proposed bills, Mr. Wilbur, you was talking about Section 9. What other sort of salient amendments are being proposed in either the bills?
So the Section 9 in the prescription law, that's a substantive amendment. There's other minor insertions of references to the Public Lands Commission, as well as a minor reference to confirmed it. When we say registrar, we're talking about the Registrar of Lands. Mm-hmm. But the substantive change of the prescription amendment bill is the amendment to Section 9, where we're allowing for where there's no dispute, the Registrar of Lands shall register a public right-of-way.
Okay.
The Registered Land Amendment Bill has a little more amendments other than just those dealing with public rights-of-ways. And I'll go through those briefly, because they're not what I would consider, they're significant but not substantive. So we've added some definitions which will allow for the use of communication technology. And I think this is something we've seen, especially during the curfew period, where we need to allow people a mechanism to do stuff electronically.
Other than the registered mail and getting stamps and the like?
Correct. So registered mail is one of them, where we're dealing with servicing of notices. Right now, the law only one of the ways the law allows by mail is registered mail. So we're amending that to add trackable service, which will allow us to use other means to serve notices. But there's other things such as stays of registration that we hope to provide Cabinet with the power to extend in the event of a natural disaster or emergency, similar to what has been done in other legislation. So it basically allows, if there's a disaster as defined under Section 2 of the Disaster and Preparedness and Hazard Management Law, 2019 revision, Cabinet can extend a stay of registration from the current statutory requirement of 14 days. We also have some provisions where we're enhancing Division 5A of the law. And Division 5A is a little interesting because it deals with dedication of lands for public use, for lack of a better term. But it's essentially some of these dedications that I spoke of earlier, where as a condition of planning, a landowner would have signed an agreement to allow this portion of their property to be used to access the beach, or to be used by public for access to whether it's another parcel or whatever the case is. But they've dedicated it using a written instrument for public use, and those dedications is what we call them. They're on the registers of these lands. Currently, Section 98D of the law provides the landowner with the authority to move those if they apply to the court. However, we want to enhance that a little bit by first requiring the landowner to notify the Public Lands Commission of their intent to apply to the court to move them, just because, again, the significance of these public rights of ways. So if there was a landowner who had a dedication and it's been being used for 50 years, we wouldn't want them to be able to apply to the court without having some regard to notifying the Public Lands Commission and allowing the Public Lands Commission to then collate information and make submissions to the court during that process. We don't also want to then unnecessarily restrict the landowner from dealing with the land they've dedicated. So currently Division 5A allows for a landowner to dedicate a portion of their land for public use, and if they want to modify or discharge that dedication, then they need to apply to the court. And just to say, we can't always look at it in a negative light. There may be circumstances where someone wants to dedicate more land, so they still need to apply to the court, but now they need to notify the Public Lands Commission before an application is made to the court.
Okay. We do have a caller on.
Yeah, sure.
Mr. Wilbur, Ms. Sophie. Let's go to the phones. Hey, good afternoon and welcome. Thank you for calling.
Good afternoon, Dwayne. How are you today?
Very thankful. How about yourself?
I'm good, thanks. This is Billy Simamba trying to chime in on this controversial issue of the two bills. First of all, let me congratulate Ms. Sophia Williams as well as Mr. Wilbur. Welcome for being so brave to come and on various shows to talk about this issue, which is very, very controversial. And I think they've done quite well in trying to explain some of the issues involved. But of course, I think there's a lot of things which cannot be explained really, but let me try to touch on them. But before I proceed, by way of full disclosure, I'm one of the attorneys at law who is representing the three West Bay ladies regarding this the beach access matter.
Yes,
so
sir.
The various officers would have seen my name on various correspondence and so on. But the specific things I want to mention are as follows. The first one, it has been raised in your previous appearances, but I'm not quite sure that I got what I consider to be a satisfactory response. Under Section 147(2) of the Registered Land Law, it says that when somebody presents a document to be registered or any right to be registered, if the registrar says that there is no, like if they don't want to register it for whatever reason, then if the person who is making the application gives a notice of intention to appeal, then it is the duty of the registrar to make a report and send it to the Grand Court. It is very clear in 147(2) that if an appeal has been filed, then the registrar shall prepare a report and send it to the Grand Court. Now, the 500 affidavits, now famous affidavits, were filed to ask for these rights of way to be registered. There was a refusal which said, well, there is no power to register it. By the way, I disagree with that. I think the Attorney General was wrong, but I won't litigate that now. But that having happened, then we said, well, why don't you then refer the matter to the Grand Court, since an appeal had been filed? And the legal advice, which was given from the Attorney General, was, well, there is no obligation to refer the matter to the Grand Court. What I want to find out is why the matter was not referred to the Grand Court when the law clearly says that if there is a dispute, the matter shall be referred to the Grand Court by the registrar. Why was that not done? Point number one. Point number two, if I can now come to the bill. You see, there is a danger in the bill, and I think a number of people have pointed this out. I was also listening to Mr. Miller a little earlier on. You don't want to create a right. You don't want to give a right to objectors, which they did not have before. The way the bill is drafted right now, it's written in such a way that somebody who didn't object during the 20 years can now say, after there is an attempt to register it, can now say, well, no, I'm objecting. The law needs to make it very clear that if you didn't object during the 20-plus years when those indefeasible rights were created, then you should not be able to object. And in any case, I believe that the registrar should have a certain power to decide. Like, for example, if the registrar feels that the objection is frivolous or it doesn't have much weight, the registrar should be able to say, I will not accept this as a valid objection. What I will do is I will give notice to you that I'm going to register it at the end of 30 days unless you either file an appeal to the Grand Court or so. You see, to merely say, well, but if there is an objection, then the matter has to go to court. That's a problem. You know how much it costs to go to court? You need about $60,000 just to settle that. So there needs to be a little bit of the power with the registrar to be able to dismiss those things which, for example, if the objection was not made in 20 years, the registrar should be able to say, I won't accept this. It is being made too late after 20 years, I will register it. Or even if there's some other reason which makes it frivolous, the registrar should be able to register it and then leave it to the landowner to go to court. Now, last point. Last point has to do with bad faith. The government if I can go back to that point about the going to the Grand Court. You know, the Attorney General, I will be bold enough to say it on radio. The Attorney General, by advising you, the registrar, to say that you have no obligation to refer the matter to the Grand Court, he committed a criminal offense. Because under Section 121 of the Penal Code, it says very clearly, if you deliberately flout the law, you have committed a criminal offense, and by him advising you to say, well, you have no power, he committed a criminal offense. And I think in Cayman we need to be able to say these things so that people can realize that the law is supposed to protect the people. Finally, the point I want to make about bad faith. In my view, the government is acting in bad faith. One, why is this matter not resolved up to this point? These affidavits were done like 2001. I only got involved in this in like last 2 to 3 years, and yet nothing has happened. The prescription land law was amended in about 2017, and yet there was no provision in there to say, well, we want to give the registrar the power to register these things. The government kept saying, well, we don't want to give the registrar the power to do this. Let's create a public lands commission, so that, it can look into these matters. In my view, the government just doesn't want to protect these rights. They are bringing this legislation now because they've been put under pressure, and therefore I think it is very important that all these pretensions towards trying to solve the problems must end, and the government has to act in good faith. Another thing that shows bad faith is this nonsense that that affidavits were filed a long time ago. It's like they are stale. To me, just the fact that that argument is being advanced, to me it shows that the government is not acting in good faith. How can an affidavit be considered to be out of date? After all, you are dealing with prescriptive rights where things happen over 20, 30 years. Then ultimately, this one is very controversial, but I will say it. The government, on the 9th of January, I appeared in court together with the other lawyer so that we could agree on certain directions about how to proceed. Do you know that after I left, within hours of me leaving court, a Crown Counsel was calling the lawyer I'm working with to try and find out what my legal position to appear in the case was. Why does somebody want to do that? In other words, they wanted to victimize me for something. So if you are in good faith, acting in good faith, and I'm also acting in good faith in representing a client, why are you trying to victimize the person who is helping to resolve a particular legal issue? I should leave it there and listen to what you have to say as an answer. Thank you.
All right. Appreciate it very much. And perhaps before we respond, just take a quick short break, and when we come back, we can get the response and continue discussion. Please stay tuned for Talk Today.
The Cayman Islands Chamber of Commerce Pension Plan. We're here for you. Are you currently a member and interested in management of your pension plan? If so, consider volunteering to be elected as a trustee at our upcoming extraordinary general meeting to be held on the 4th of November. Please visit our website, chamberpension.ky, or email pensions@chamberpension.ky for further details. The Cayman Islands Chamber of Commerce Pension Plan. We're here for you.
Stronger, wider, higher, lighter. The all-new Ford Ranger Raptor.
Powerfully built with a 2.0 diesel Panther engine and 210 horsepower. Modern with leather interior and 8-inch touchscreen, Sync 3 technology and power features. Tough, built to handle the off-road with 4-wheel drive, terrain modes, and a 10-speed automatic transmission. Coming early October to Vamped Motors, Walkers Road. To find out more and to test drive the bold new Ford Ranger Raptor, visit Vamped Motors, Walkers Road, or call 949-8288.
I am Acting Inspector Kevin Bull, Area Commander for the Sister Islands. The RCIPS and Cayman Brac Police Station wish to inform the public about the new installation of school zone signs and amber flashing lights. These lights and signs are located in the area of the Creek and Spotgate Primary and Junior Infant School, the West End Primary School, and Lehman Eastcott Senior High School. Motorists are being reminded to practice safe driving habits every time you get behind the wheel and to drive within the speed limit of these islands. The speed limit of school zone when the amber lights are flashing in the morning and afternoons on weekdays is 15 miles per hour. Persons found in contravention of this speed limit during the school zone times will be ticketed. Please note there is a $40 fine for every mile over the limit. Anyone found driving more than twice the maximum speed limit will be warned for intended prosecution and, on conviction, be disqualified for a minimum of 6 months. Thank you for your cooperation and the part you'll be playing in keeping our children of Cayman Brac safe by driving within the speed limit.
RC Fusion.
Monday to Thursday.
10 a.m. to 12 p.m.
Fridays. Radio Cayman.
Biggest variety in the morning. Biggest variety. RC Fusion.
Following the 10 a.m. news headline.
Biggest variety in the morning.
Talk today. But I do have some questions. Talk today.
Cayman Islands' foremost listeners' participation program.
Talk today.
Because there are more questions than answers.
What the public is saying.
Waiting to take your calls right now. Sterling Dwayne Ebanks.
Good afternoon. Welcome back. Thank you so much for joining us. We have the Registrar of Lands, Ms. Sophia Williams, together with Deputy Chief Officer, Mr. Wilbur. Welcome as our guests. And we're looking at two bills going to the Legislative Assembly in short order for the prescription law and the registrar land law. So, well, we had a caller prior. I'll leave it to Ms. Sophia, Mr. Wilbur.
Just want to thank Mr. Sibamba for his call. I think many of the points he raised in the call are currently in a case before the court, so I wouldn't want to comment too much on a lot of them. What I would invite is if he could send his comments on the bill in writing to the minister so we can duly consider them. I can advise that from my perspective as Deputy Chief Officer, the intention is not to be acting in bad faith. We want to register these rights of ways at this time. I can't speak to what happened previously and the prior issues, but we are willing and ready and wanting to and desirous of registering these rights of ways to protect them and enshrine them for future generations to use. I also want to add that the amendments to the prescription law do not add a new dispute mechanism. It simply adds that if there is no dispute, the registrar shall register. The dispute mechanism as drafted will remain. So I know that may be interpreted different ways, but again, we're not adding a new dispute mechanism from the amendments we're making to the prescription law.
Ms. Williams, if you wish to.
I will. Again, I would not comment on the matter that is currently before the court and the advice that is given by the Attorney General, who is our legal advisor. However, in relation to the affidavits that were submitted in 2001, What we're trying to achieve is what the affidavits were trying to achieve in 2001. I am unable to say why no action was taken in 2001 up to when I assumed office. But at the very least, what I do believe is that the government is not acting in bad faith. What they're trying to achieve is that they're trying to achieve the registration of these prescriptive beach accesses, which is the same that the concerned citizens want to achieve. And in my opinion, what this bill is seeking to do is ensuring that the registrar has explicit powers to register these beach accesses, because there is a school of thought that if you are conferring a particular authority on a public body, it must be conferred in a law. Mm-hmm. And if it is not conferred, then we may be acting outside of our powers and ultra vires the law. So what the government is not acting in bad faith. What the government is trying to achieve is less dispute between landowners and the general public, to preserve the beach accesses for all persons in the Cayman Islands to use. And we are hoping that this is what we are attempting to achieve by the legislation, and what we really do want is for persons to send in their comments. If they are comments, for example, one of the earlier comments was the registrar should have the powers to decide a matter unless you have filed an appeal to the Grand Court. That is something that really should be sent to the ministry for their consideration and for their comments. So we do encourage persons, I think, before the 21 days has expired, that they put these in, because we want to start protecting these beach accesses. And a great way to start protecting them is to have them registered just as how they had wanted to see them registered in 2001. Now, it's very difficult. What I would encourage persons to who are listening is that, yes, we are agreed that the registrations did not take place in 2001 or prior, but we are starting to make an attempt now. And it is exactly what they've asked us to do, register these beach accesses, and the government has looked at it. They've taken all the legal advice, and they're saying this is what we're hoping to achieve. And we're hoping to achieve what you have asked us to achieve. So I would say to the persons who are listening that you need to give the Public Lands Commission an opportunity to see whether how they are going about protecting these beach accesses, that we're going to have them registered, and that it will be is noticed to the world that these rights exist, which should lead to a lot less disputes concerning these accesses. And I think that's it on my end. But in relation to, I want to remind the public again that the government is actually trying to achieve the same thing that the public is trying to achieve, which is the protection of these public beach accesses for the Caymanian people.
I just want to add the 21-day period. I know people get a little confused about that. That is merely the statutory requirement for a bill to be published before it's heard in the LA. You can still comment, send in your suggestions. So I know our bill was published on the 16th, so 21 days technically I think would be today. What's today? Yeah, maybe today or thereabouts. But feel free to send in your comments afterwards. Tomorrow, Friday, over the weekend, Monday. The 21 days is merely a statutory obligation to publish the bills. So you still have time to comment if you want to send in written comments.
How would the public, where do they send their comments?
They can send comments to the plc@gov.ky, or they can send it directly to myself, wilbur.welcome@gov.ky, Wilbur with a U. So we're more than happy. I mean, if they want to drop them off at the reception counter.
All right.
Yeah.
Well, I know that you've got to get back to things after 2, but we do have one other caller joining us. Let's go to the phones. Good afternoon and welcome. Thank you for calling.
Hello. Good afternoon to you and your guest, Mr. Wilbur.
Buenas tardes, sir.
Yes.
Good afternoon, sir.
Good afternoon to you. I just came in at the tail end of the last call, right at the end. So forgive me if I'm asking a redundant question that's been asked already. But, and I know, Mr. Wilbur, I believe you're totally honest. You do not know the reason why. However, Ms. Williams is in the Department of Lands and Survey, where these affidavits were. I'm sure she's aware of the stories of how they tried to be hid until in 2014, we got word from within Land Registry and another department of government whose desk these boxes had been put. And when we met with the then chairman of the Public Lands Commission, he told us that they were stale and they had to be redone. We had to tell him that truth is never stale. Truth is eternal. Truth doesn't change. When you make up stories, you got to change your story to suit the people and to suit the audience. But an affidavit is a statement of truth, unless somebody proves it is not truth. And in regards to having faith in the government, I'll say right now, I have zero faith in government to do what's right in this matter. As in regards to the attempts of Mr. Wilbur, welcome to do what he's doing. I have the utmost of respect for him. The utmost of respect for him. And it burns me, some of the things that I have said to him and would probably still need to say, because he has been put forth as a person by government when there are others there in government who know how they have failed the Cayman Islands people over the years in these matters. But Mr. Wilbur, please, nothing is ever said up to this point in time personally against you, sir. You have been exemplary. And I can't say that for very many people in this matter. Matter of fact, nobody else on government. Now, what is also happening is that in some of the amendments that are being done to the registered land law, without rehashing everything over, like for instance the Section 98, which they introduced just in recent years to extinguish dedicated right-of-ways. And now they're wanting to even make it retroactive. They want to rewrite history as if our past didn't exist and it was never there. How wicked can the government get? And I use the word wicked intentionally. It's not a slip of the tongue. How wicked can they get to try and do that to our people? And they never cease to amaze me with what they're doing. And I have no faith that they are trying to do what is best. Mr. Wilbur, I believe you. I believe you're trying. But you have to work with these people that do not mean us well, that do not mean to do what is necessary, because they could have done all along what is doing in this law, and some simple amendments to Section 138 could have covered a problem that didn't really exist, but they say existed in regards to public. But every one of those right-of-way affidavits, about 500 that are sitting there, those are from individuals talking about their individual use of the properties, that they went on these properties. And some of them went there from time, as one lady I'll never forget said, from time I can remember myself. I said, normally I don't ask a lady how old she is. She said, well, I'm 55 years old, sir. Mm-hmm. This is the type of thing. Her parents went there, and our government is trying to rewrite history and change it.
Mr. Billy, I hear the challenges and perhaps as Mr. Wilbur shared, this is an opportunity. Maybe it's a continued discussion, and maybe it's just an indication of things to come if we don't get it right. Ms. Williams?
Just to say that Section 98 does not apply to the prescriptive right-of-way. What it applies to is these dedications where persons voluntarily dedicated a public right to the beach, or it was a condition of planning approval. So on the plain grammatical meaning, the court does not have the power to modify or extinguish a prescriptive beach access. So that's the first thing I want the public to understand, that Section 98 is not granting the courts the power to modify or extinguish a prescriptive beach access. It's mainly in relation to dedication, where a landowner had voluntarily dedicated a public path to the public, or it was a condition of the planning approval.
Yeah, and just to add to that, as Mr. Billy Adam rightly said, 98 is a relatively new section to the law. So that means we would have had persons who dedicated lands for public use prior to this section of the law being added. What we're simply saying is those persons that dedicated those lands back then, those dedications are to be treated as if they were made under this section of the law. And again, it's a very good opportunity to make the distinction between dedicated public rights of ways and prescriptive public rights of ways. So dedications are most commonly registered. I can hazard to say all of them are registered, but I would say 99% of them are registered because, again, it's a dedication is a written instrument where someone approves or the landowner approves the public to use a portion of their land. So those are registered. And we've had those instances before this section of the law came into force. And what we're trying to do with this provision is saying those that were done in that manner prior to this section of the law, they should now be treated as if they were done under this section of the law. It's a good opportunity to make that distinction. Prescriptive right-of-ways are indefeasible, can't be moved. Dedications are still the property of the landowner, and currently under the law they have the authority to apply to the court to request to move it or extinguish it. The change, like I said before, they were hoping to make is that before they can even apply to the court, they now need to notify the Public Lands Commission to say, hey, Public Lands Commission, we're hoping to move this dedication of land that we had dedicated to public use from the west boundary to the east boundary, or we want to change it from being 6 feet wide to 12 feet wide. So prior to that, as the law is currently written, a dedication, they simply need to apply to the court without notifying the Public Lands Commission at all.
All right. Thank you both very much, and I commend you for coming out. Invite you to, whether this issue or others as it concerns us, to extend the invitation to join us as you wish.